Let's talk about everyone's favorite topic, fiduciary breach litigation. So it seems like the fiduciary breach litigation is constantly on the rise as we're regularly seeing headlines touching on this case or the other. But Boston College's Center for Retirement Research recently took a step back and actually quantified the volume of fiduciary breach litigation cases in recent years and how that's been trending both in total and by topic. A couple interesting findings from their research. First, fiduciary breach litigation really has been on the rise in the past few years, but that follows kind of a lull in new cases that occurred between about 2012 and 2014. Keep in mind, though, the timeline for fiduciary breach cases can be pretty long. It can be many years between when a case is initially filed and when it's ultimately closed out, whether that's through a dismissal, a settlement, or, in rare occasion, the case actually having a definitive ending from the court. So what are the most common types of fiduciary breach cases? We hear a lot about excessive fees, and that's been a big focus for a lot of committees in the last 10 years. But actually the most common type of fiduciary breach allegation is about inappropriate investment options, whether that's company stock related or alleging that an investment option offered in the plan didn't perform sufficiently relative to a benchmark, didn't have sufficient manager track record, or that there was some other factor that indicated or should have indicated to a committee that the investment was imprudent. That being said, excessive fee cases, definitely common, and we've seen a lot of those in recent years. Self-dealing cases have been on the rise, though, as the growing area of fiduciary breach litigation. In a self-dealing case, a participant's alleging that a fiduciary or fiduciaries were acting in their own best interest and not in the best interest of participants. These cases have become more common in the past 3 years, particularly for financial services firms. Investment managers or record keepers themselves have faced allegations for participants that when including their own proprietary products in the plan, an investment option, or the record keeping system, that they breach their fiduciary responsibilities to their own participants. So what kind of outcomes should you expect from a fiduciary breach case? Well, in short, not a lot. Of the 430 cases that Bloomberg has identified in the past 10 years as fiduciary breach claims, 260 of those, almost 70%, are still pending. So quite a long timeline to wrap up one of these fiduciary breach claims. The next most common outcome from a claim is a settlement. The next most common outcome from a fiduciary breach case is a dismissal, followed by settlement, and lastly, an actual finding in the case. Of the 430 cases, only 12 of them actually had a finding from the court. So very rare that the court actually is weighing in on a final decision related to these cases. But with so many cases still pending, a lot of opportunity in coming years for courts to have more opinion in the space.